Hey everyone, I am Parushi Sharma. Currently I am working as an intern with LEXIS and Company, and today I will talk about the topic independence of judiciary. So for a democracy, an independent judiciary is a must-have thing, because a judiciary without independence is same as a lion without his teeth. And independence of judiciary means the capability of judiciary to perform its specific duties without any external and internal control. So, if a judiciary is performing its duty without the interference or influence of government or any private entity, so we can call it as a independent judiciary. So, why we need an independent judiciary? So, as we live in a society, and the society have diversity and lack of consensus between the individual. So, disputes in a society are very common. So, to resolve these kinds of disputes, we need a body which is unbiased, so that a fair justice system will conduct justice. So, independent judiciary promotes supremacy of law and ensure fair justice system. If we assign an individual to resolve disputes between individuals, in this scenario, there is surely a chance of involvement of personality guts of an individual in the justice system, and an independent judiciary is necessary to maintain the checks and balances between individuals and society, and it also checks the functioning of other organs like executive and legislature. And now we will talk about the components of independent judiciary. There are many things which shows us that our judiciary is independent. First is separation of power. In independent judiciary, judge have power to work without any political or pressure or without any influence of other organ of government. Judges are not forced to act or in favor of any political party or any agenda, so that everyone could get impartial justice. No government or private entity can interrupt in the administration of judiciary. The second thing is financial independence. Our judiciary and judges are financially independent because their salary and allowances are directly extracted from the consolidated fund of India. Even their salary is set by the parliament, but they cannot decrease their salary. They can only increase the salary of judges. They can decrease the salary of judges only in one condition, when the India is facing from financial emergency, which is Article 360, and this article is not used so far in our country. This is the only unused article of our Indian Constitution. Next thing is appointment of judges. So, in the process of appointment of judges in India is known as the collegium system, where CJI and other senior most four judges of Supreme Court gives recommendation to the president, and this recommendation is bound to the president to appoint the judges of Supreme Court. And in case of appointment of judges of High Court, one CJI and two senior most judges of Supreme Court is necessary. So, in the process of appointment of judges, there is no any influence of the parliament. So they don't have any fear of a political leader or of a political party, because they are elected on the basis of their experience and knowledge. Next thing is fixed tenure. So tenure of judges fixed. That's why no one can easily remove him. Even parliament cannot remove them if they take decision against it while working constitutionally. They have no fear of losing the authority because they have a security of tenure. Even when they act unconstitutionally, there is a difficult procedure for their removal, which is also known as impeachment, and it is exactly equal to the impeachment process of a president, in which two-third majority of both houses of parliament is necessary to impeach a judge. And there are some grounds of impeachment of a judge, which are as follows. First one is misbehavior or violation of a constitution and incapacity to hold the office, and third is the use of an excess power. Only and only in one of these criteria we can the parliament can initiate the process of impeachment in the parliament. And next is no discussion in legislature on the conduct of judges. Yes, the judgment of a judge is not discussed in a parliament. They are not authorized to discuss about the judgment. Even they cannot criticize the judgment of a judge. Parliament is not entitled to discuss or criticize the judgment of a court. Only the process of impeachment and of judge is discussed in parliament. No one can disrespect or neglect judgment of courts. If they do so, they will be punished as in a contempt of courts. And next thing is power to punish for its contempt. Yes, our judiciary or courts are empowered to punish the individual or any entity who contempts the court. Contempt of court means disrespecting, insulting, and ignoring and harming the dignity of court. In these cases, if a judge, magistrate, or any person who is working legally can also be punished in the same way as an individual is punished in the case of contempt of court. There is a famous lawyer and activist Prashant Bhushan who was fined with 1 rupee for the criminal contempt of courts. Next power is power and jurisdiction of Supreme Court. Yes, our Supreme Court has several powers and jurisdiction. Some of them are as follows. First one is original jurisdiction, which is Supreme Court can resolve the dispute between the center and states. Second is appellate jurisdiction. It is the highest court of appeal. Anyone can appeal against the judgment of lower courts in Supreme Court. And writ jurisdiction. In case of violation of fundamental rights, Supreme Court can issue a writ, and that's why it is also known as the custodian of fundamental rights. Fourth is advisory jurisdiction. Supreme Court can give the aid and advice to the president, but this advice is not binding on him. Next is judicial review. Supreme Court can review any acts and amendment made by the parliament. So these are the power and authorities given to our judiciary, which shows that our judiciary is an independent judiciary, and India's judiciary is one of the most empowered judiciary. But there are some factors which are affecting the independence of the judiciary of India. First one is corruption. Second one is absence of transparency in appointment of judges. Third is influence of political party. Fourth is interference of other organs of the government, and last is dominance of powerful entities. These all factors are affecting the independence of judiciary. The independence of judiciary hold a prominent position as far as the institution of judiciary is concerned. But as it is clear from the historical overview that judicial independence has faced many obstacles in the past, especially in the appointment and transfer of judges. But court took its stand in every situation and proved that the independence of judiciary is a basic feature of our constitution. Thank you.